Good afternoon, everyone. Good afternoon, Gustavo and Alessa. It's very nice to have you today. Good afternoon to our attendees. I see that people are still joining, but I believe the time is for us to gradually start. Good afternoon, everyone. I'm happy to introduce today our two distinguished panelists. First of all, Alessa Pang, who is joining us from Singapore and who is a partner at WongPartnership in Singapore. And the second panelist is Gustavo Laborde, who is based in Paris and who is a partner at Laborde Law. Both Alessa and Gustavo have first-hand experience, including experience with creeping expropriation and expropriation in general in investment arbitration. So they are the best suited to enlighten us on all the intricacies of these problems. And I will now give the floor to Gustavo and Alessa, just maybe to briefly introduce themselves if they would like to add something to my short presentation.
Okay, I'll just go first very briefly. I think as Vera has very succinctly introduced me, I'm Alessa. I'm a partner at WongPartnership based in Singapore. I'm with the Commercial and Corporate Disputes Department practice group at WongPartnership, and my practice area largely comprises commercial and investor state arbitration, as well as quite a bit of arbitration-related litigation, so quite a bit of work relating to enforcement of awards, setting aside awards, and anti-suit injunctions. And that also happens to be my special area of interest.
Good afternoon, Vera and Alessa, Vera and Margarita as well. Thank you very much for the invitation. It's very nice to be here. I've been practicing investment arbitration for the last 15 years, and that's essentially my background. So I'm looking forward to this discussion on creeping expropriation.
Fantastic, thank you so much. A brief introduction from my side. My name is Vera Bykova. I did the MITS LLM in 2020 in Geneva, and I'm currently working in Geneva. And I'm also qualified in England and Wales as a solicitor. And it's a pleasure to be here virtually in St. Petersburg because I happen to be born there. And I just looked at the weather is quite chilly there. It's like 2 degrees in Celsius. So it's much colder, I guess, than in Paris, Geneva, and Singapore. But we will try to make it warm today in this nice virtual meeting. So the topic today is at the same time narrow and broad, the creeping expropriation. And we have a quite experienced audience. Most of our audience are students who spend months preparing for this moot court competition. So they definitely know that the general notions of direct and indirect expropriation. But still, I would like to ask Gustavo and Alessa, what is this mysterious notion of creeping expropriation? Was it necessary to introduce it? What is the particularities of this term? And why do we need it at all? Wasn't it just enough to have direct and indirect expropriation? So Alessa, if you would like to start.
So I suppose, I mean, for me, I like to start things by setting the context. So I know everyone knows what expropriation is, but let's just start with the basics. So generally defined, it refers to a state taking property belonging to a foreign investor. And if unlawful, it will trigger international responsibility of the state. And as Vera has pointed out, expropriation can be direct, meaning that it would result in the transfer of a legal title to the property, or in some cases, a physical seizure of the property. Or it can be indirect. So the property in question is not necessarily destroyed, but the owner, the foreign investor, is deprived of his or her ability to manage, use, or control the property in a meaningful way, or its value is substantively diminished, but the legal title is actually not affected. So creeping expropriation is a subset of indirect expropriation. Why do I say it's a subset? So indirect expropriation can come in the form of one act, one indirect act, which results in, in your property an investor being substantially deprived of its use of this property. Or it can be the result of or consequence of what we call a series of acts or sometimes omissions, which over a period of time can ripen into an expropriation. So at some point, it starts with a gradual step. It starts with small steps, but at some point, you realize that actually the property in question has been indirectly expropriated. So usually how it manifests, the most common way it manifests is in the form of regulations by a government. And it slowly, as the name suggests, creeps on the investor before the investor realizes, my property has been taken, so to speak. So generally how one would look at it is there is, as I've mentioned, there is a chain of events, and what eventually culminates in is what we sometimes call the final straw. And this sometimes determines the date of the taking or the date of the expropriation. And this notion of the date will come in again. We will discuss this in some detail again, because the distinctive feature of creeping expropriation is this temporal nature. So it takes place over a period of time, which can affect A, jurisdiction of the tribunal, which is something we will discuss next, and B, how do you assess the value of the property? Because value is determinative of the assessment of loss of the investor, assuming expropriation is found. So expropriation is not just some sort of creeping expropriation is not just found in it's not something that has just been discovered. In fact, if you look at Article 15 of the International Law Commission Articles of State Responsibility, it does talk about the breach of an international obligation by a series of actions or omissions, which we find in aggregate as wrongful, occurs when the action, which taken with the other actions or omissions, is sufficient to constitute the wrongful act. So the breach, subparagraph 2 states that the breach extends over the entire period, starting the first of the actions and lasts for as long as these actions. And why creeping expropriation, just to end off very briefly, is why it's become more relevant, is because it's generally been acknowledged that direct expropriations have become more rare, so to speak. States would be less inclined to just go on and directly take or physically seize property. Whereas generally, what has become more common would be, or at least in the form of these exit cases, what you see more common now, if there's expropriation involved, would be indirect expropriation, or in this case, creeping expropriation. So I hope that helps set the context.
Thank you so much, Alessa, for setting out the background and grounds for our discussion today. This is very interesting and helpful, what you've mentioned. Indeed, what comes to mind is the famous quote from the Siemens Tribunal, when the tribunal said that basically the last act in the chain of events in creeping expropriation is basically as the last straw that broke the camel's back. Just to give some imaginary image of how it works and how the tribunals come to this conclusion. Just one follow-up, maybe the question will go to Gustavo about the definition of creeping expropriation. So basically, Alessa mentioned that there shall be some steps in the chain of events, and only the last step, the last event will basically broke the camel's back, will crystallize the violation of international law. But my question would be, is it indeed necessary that the previous acts, if we take each of these acts separately, that each of them does not amount to expropriation as such, or to any violation of international law? Or can, in some circumstances, do tribunals or courts found that it is possible that some separate acts were also in breach of international law, but they still chose to look into the entire picture of events?
Vera, if I may actually go back to your first question, because it's a great question and I haven't had the chance to answer it yet.
Of course, my apologies for not giving you the floor as well.
So the first question is, why do you need the definition of creeping expropriation? It's a great question, because you already have direct expropriation and you have indirect expropriation. So why do we need an additional concept? And I think here the rationale is that there is, if we can call it, a loophole in the definition of indirect expropriation, which is it tends to focus on a single act or a single omission. And if you check that focus, then you could leave out a composite of acts which taken together could lead to the same result as a one act indirect expropriation. So if you focus, let's say, on the perspective of the investor, right? From your perspective, if the state substantially deprives your investment of value by one single act or by 10 different smaller acts, from your perspective, it's the same. So it would be unfair to say, oh, okay, when it's a single act, you've got indirect expropriation, but if it's multiple acts, you've got nothing. So the concept of creeping expropriation is meant to address that loophole. And the second facet to this is that, of course, you don't want to create the wrong incentives where states could be in a position where they would not be held liable if they accomplish the same result through a series of acts. So if instead of taking one single measure that deprives the investment of value, they do it in 10 steps, well, as a state, you would say, okay, well, let's do that, because then we're not held liable. So the concept of creeping expropriation is meant to avoid those wrong incentives and to avoid the unfairness of not giving the claimants, the potential investor, a remedy to address that. So it really is a class of its own within the universe, the set of indirect expropriation. And I think there is an elegant analytic symmetry between, as you well know, that usually one says that you have to look at the investment as a whole, right? Whenever a claimant brings an investment claim, they will always often argue, you cannot focus on just this element or this contract or this contribution. You have to look at it as a whole. It's a holistic approach. So the equivalent of that in the universe of expropriation would be, you also have to look at the state measures as a whole, right? So there's a symmetry between this approach of looking at this as a whole for the concept of expropriation and looking at the investment as a whole. So I see that as an elegant symmetry in the system that makes sense.
Thank you so much. Yeah, that's indeed very interesting. And if I may take you up from here, you mentioned that you said at a certain point that a state shall not benefit from the manner in which it decided to implement the expropriatory measure or measures. I would like to ask you about, in this context, about the valuation date and damages. How does the concept of creeping expropriation affects the valuation date? Because indeed, we all know that the date of valuation is normally the date, like the moment right before the taking of the property, in order not to allow the state to benefit from like the manner in which it affected the investment and its value went down after the measures. So usually the tribunals take as a matter of principle the moment before the taking, but in some circumstances the tribunals enjoyed some discretion to move the date of valuation in order indeed not to permit the states to benefit from the design of the architecture of their expropriatory or other unlawful measures. So how does the tribunals approach this question in the context of the creeping expropriation?
Alessa, you want to go first, or should?
Please go ahead. Please go ahead.
Yeah, let's do this. As you know, creeping expropriation is a chain of acts or omissions. So you have a chain of, right? It's like a chain of acts. So the question is, at what point in the chain you decide this is when expropriation happens? So that's one issue. And the second one is what you just raised, Vera, what is the valuation date? On the valuation date, there are essentially three main approaches in the literature. The first one is you take the first point in the chain. And the reason for that, I mean, the rationale, and I'm not saying this is my position, I'm just saying this position exists, is that by the time the creeping expropriation happens, the property, the investment, we have already been substantially deprived of value. So the only way you could fully compensate is if you begin from the first act of creeping expropriation. Now, the second position is to say, no, you have to focus on the last act in the chain. And the reason for focusing on the last one is because between the moment you have creeping expropriation and the last act, you could still have additional investments. So the only way you can fully compensate for those remaining or additional investments is to focus on the last act. So those are, the two views. And the third view, which is probably the prevailing view, is, well, you have to focus on the moment of creeping expropriation, which is usually somewhere along that line between the first act and the last act. So just as in a traditional expropriation, you essentially would focus on that act that would be the tipping point. That is the act after which you could say that the investment has now been substantially deprived of value. So let's take, I don't know, let's assume that we're talking about 5 different measures, right? 1 to 5 that amount to this creeping expropriation. And let's say that the creeping expropriation finally happens at step 3, right? And 4 or 5 are sort of extra damage, but you already have creeping expropriation by step 3. So what you would do is you would focus on the fair market value as per standard or classic BITs right before step 3 to determine what the value of the investment was at that point.
Okay, thank you so much. So it's basically a very factual analysis, and the date of valuation becomes somewhat a movable feast that can be changed, and in some way the parties don't necessarily know what the outcome will be, correct?
It's a very difficult judgment call, indeed. It is a very difficult judgment call. And if I may share briefly a personal experience, one of my first ever cases in which investment arbitration, I was involved as tribunal secretary. It was a case where the claimant alleged creeping expropriation and also indirect expropriation. It's a public case, so I can talk about it. It's an exit case. It's Burlington against Ecuador. And the claimant was represented by a little-known firm called Freshfields, and together with Professor James Crawford. And James Crawford was in charge at the hearing of presenting the argument on creeping expropriation. And so you had essentially 4 main measures that were at stake. It was the initial one was where the state had imposed a 50% windfall tax. Second one, they increased that windfall tax to 99%. The third is after the claimant, the subsidiary stopped paying this tax, they seized the oil, and when the claimant, they cease operation, they essentially stop operations of the oil blocks, then the state seized the blocks altogether. And so claimant via counsel Professor James Crawford argue creeping expropriation and also indirect. And it's a very difficult always judgment call for tribunals to make. At what point in the chain they decide there is expropriation. So I'm not sure that you would say that it's a matter of full discretion, because tribunals still want to think of themselves as being bound by rules. But it remains a difficult judgment call to decide, well, at what point this would become a substantial deprivation.
Okay, thank you so much. I can't help but to ask Gustavo and Alessa a very general theoretical question. If in the context of the creeping expropriation, the date of valuation is kind of movable, it can change, isn't that one of the problematic points in general? Because nowadays there is a lot of criticism of the system of investment arbitration, and sometimes some states were saying that look, if in the BIT, there are a lot of issues that are very vague and broad, like fair and equitable treatment. There is no definition in the treatise, and the practice just invented in a certain way the content of what is fair, what is equitable. Isn't this in some way similar when we have like the creeping expropriation, but it's vague in the sense that there is no definition in the treatise, what shall be the date of valuation, how we shall treat this type of situations. Isn't that problematic? Shall this be regulated? Shall we add in the modern new BITs more details about the creeping expropriation and how different issues, let's say damages, valuation date, or jurisdiction shall be regulated? Or shall we leave it open as it is now?
I think my personal view is this. I think it would be difficult to cater for every kind of situation. And I mean, the reality is this creeping expropriation, as we have discussed as to date, as of now, in the last 20 minutes, it's a very fact-specific analysis. But I don't think it is a lot more vague, a lot more vague or a lot more arbitrary as compared to determining any kind of other breaches. I suppose where the main difference is you're looking at a composite of acts. But the reality is as you look at these cases, the tribunals are still able to kind of ascertain at some point, and I think various tests or so-called tests, tribunals have tried to establish various so-called tests to kind of pinpoint some sort of certainty, so to speak. So, for example, in one of the cases I am unable to pronounce is Campania and Costa Rica, where you had the tribunal describe the notion of creeping expropriation as gradually by small steps until it reaches a condition where it can be said the owner has truly lost all the attributes of ownership. And in that sense, this sense of losing attribute of ownership, it could be equally vague even in the context of a single act of expropriation, a single act of indirect or direct expropriation. So I don't think the fact that it is vague or arbitrary necessarily undermines the legitimacy of such a claim. Although, of course, it would not hurt if, let's say, BITs could possibly cater with more certainty of determining the date of valuation in certain cases of creeping expropriation. But whether or not there would be an incentive for states to have this in their BITs, I think that's a different question altogether.
Yeah, that's for sure. There are different interests in stake, and sometimes it might be actually against the state's interest as well to have something very well defined. Gustavo, any views on this?
I agree with Alessa's views, and I think, well, there's been a general debate as to whether BITs should be a little bit more detailed, it's a difficult question. I think it's some people argue that tribunals have far too much discretion and therefore power, and that you cannot leave investment arbitrators have so much power. But on the other hand, you cannot codify in detail because you need to leave a level of discretion to judge. What Alessa correctly said is a very factual issue to analyze on a case-by-case basis. So I think there could be some benefit in some added clarity in BITs without getting to the level of amounting to a civil code or something that is over-regulated.
Okay, thank you so much. If I may follow up, we have discussed the evaluation date, so we kind of started from the end of the arbitration process. But as Alessa mentioned, indeed, there are various temporal issues that creeping expropriation might raise. And I would like to come back to the very first step, the assessment of jurisdiction. And the question will go first to Alessa, how the jurisdictional issues in respect of the timing are assessed in the context of the creeping expropriation. Because what comes to mind, there may be a situation when the BIT enters into force on a certain date, and some acts in the chain of events, they happened before this date, and some happened after. So what the tribunals, how shall they approach and how do they approach such types of situations?
Yes, so I mean, as we all know, jurisdiction is critical, and it always often comes to the fore in any investor-state treaty arbitration. And one of the issues is always what we call temporal jurisdiction, because generally international investment agreements impose temporal limits on jurisdiction. So most IIAs would cover investments or acts by state after the enactment of the treaty, after the treaty comes into force, and they will expressly provide for it. So you see this, for example, the India model BIT, which says that this treaty shall not apply at Article 2.3. It shall not apply to claims arising out of events which occurred or claims which have been raised prior to the entry into force of this treaty. Although sometimes there may be IIAs which may be a little bit more vague, or in certain cases or in most cases, actually in many cases where the IIA doesn't say anything, then what happens? Then often investors can run into an issue because there's this principle of non-retroactivity, which is defined in Article 28 of the Vienna Convention. You see in Article 13 of the Responsibility of States for Internationally Wrongful Acts, which is, and I think I would just read this: an act of state does not constitute a breach unless the state is bound by the obligation in question at the time the act occurs. So then it becomes logical. If the treaty is not enforced, then there is no obligation on the part of the state to act in a certain, there's no obligation on the state. So whatever acts that had occurred before the entry into force of the treaty cannot be determined by the tribunal. So whether or not it was a breach, I mean, it can't be a breach because the tribunal wouldn't even have jurisdiction to find that there was or wasn't a breach. So you've seen this issue arise in certain cases where tribunals have expressly said, we only have jurisdiction over disputes that arose after the treaty's entry into force. So where a tribunal is asked, can we have jurisdiction over a violation which occurred before the claimant became an investor, but the effects of which continue afterwards? And tribunals tend to take the position that no, we don't have jurisdiction over acts or violations. I mean, they're technically not violations, which had occurred before the claimant became an investor under the IAAs. And this, as I said, because this becomes highly relevant and pertinent to creeping expropriation because of its distinct temporal nature, where you can have acts which had occurred before, as you pointed out, before an IIA enters into force, and then you have the rest of the acts happening after. So does this mean, what does this mean for the acts which had occurred before? Does it mean that it becomes completely irrelevant, that the tribunal cannot even consider it at all? Well, so first of all, really establish that the tribunal cannot in any way determine whether or not there was a breach. But how tribunals have tried to come about, tried to not say circumvent this, but how to deal with this is that they have found that actually it can still consider these acts for the purposes of understanding context, background, the causes, intent, or the scope of the violations of the BIT. So that what occurred after the BIT came into force, you view that as against the background or whatever happened before the BIT came into force. And this is not something that tribunals have just come up with. There's some legitimacy to it. So I was just looking, and there's paragraph 11 of the commentary to the draft articles on responsibility of state. So where it says that where a relevant obligation did not exist at the beginning of the course of conduct, but came into being thereafter, the first of the actions or omissions will be the first occurring after the obligation came into existence. But there is a clarification after that this doesn't prevent a court taking into account earlier actions or omissions for other purposes. So to establish a factual basis for the later breaches. So the fact that, that after the entry into force of the BIT, that there were various regulations or legislation that had been enacted it built on previous legislation. You can still refer to the previous legislation as the basis for these other creeping expropriation acts that took place after that the BIT came into force. And this can also be relevant to providing intent.
Okay, thank you so much. So if I understood correctly, the tribunals still in most cases look into these previous facts in order to better understand the background and the context. I'm just thinking in practical terms, it's even hard to maybe totally separate these previous facts, because when the tribunal receives the statement, the request for arbitration and the statement of claim, obviously claimants, investors, they will put all these previous facts that they consider relevant. So, and the tribunal will still be somehow, in my view, influenced maybe by just reading what happened before the entry into force of the BIT. So, Gustavo, what is your view on this?
Thanks, Vera. Well, I think Alessa covered this very well and comprehensively. And so, indeed, the starting point is treaties, including investment treaties, are in principle non-retroactive. So, unless you find some specific wording or some provision in the BIT, the starting point is non-retroactivity. Now, going back to this scenario, Vera, that you asked about. Let's go back to, remember that hypothetical I put steps 1 to 5, right? So you have this creeping expropriation now let's say that it happens at, step 4, right? You have 1, 2, 3, 4, 5. And the step 4 is when the creeping expropriation will finally happen. But the BIT or the investment treaty just enter into force after step 3. What that would mean, applying what Alessa just well explained, is that the tribunal could not take into account steps 1, 2, and 3 to decide whether there is creeping expropriation. They could use it as context to establish facts or potentially intent. But let's add to this hypothetical that each of these steps diminish the value of the investment by 20%. Let's say step 1 was 20% less, step 2, 20% less, step 3. Right? So by the time you get to step 3, the value of the investment was diminished by 60%, right? Now, the tribunal could not use this to rule that there was creeping expropriation. So they would only have to start counting after step 3. And so let's assume that step 4 was another 20% diminution in value of the investment. They could only say, okay, well, as far as applicable jurisdiction, I can only consider that the value of the investment was diminished by 20%. I cannot take into account the previous 60% because I just don't have jurisdiction ratione temporis. And so this is to present it, of course, in a very simple, clean way. Of course, in practice, is always far more complicated. So the 60% the tribunal could not take into account, and that likely would mean that they cannot really reach a finding of expropriation. Now, if there are further steps going ahead, they could still take them into account for this potential expropriation finding. And so that's my basic understanding of how it applies. And given all the questions you're asking about this, I suspect that it may be relevant for the moot case.
We are like the rules of the moot preclude us from discussing anything related directly to the case, so it might be relevant or might be not relevant, but it's definitely very, very interesting and helpful, and I find it very fascinating, the discussion. And if we complicate it even further, what comes to mind is that this notion of creeping expropriation, that this notion existed for quite a long time. Even the earlier cases like Metal Clad, they already defined what creeping expropriation is. But rather recently, if I'm not mistaken, 2011, El Paso case came up with the notion of creeping fair and equitable treatment violation. So what is this like? What is this? Do we need this concept? What is this? What are your views on this? And maybe the floor will go to Alessa to start.
Yeah, so I mean, I was just looking at the El Paso case, but just looking at this, I was very, very fascinated by it because I think in that case, what the tribunal did was to effectively really draw an analogy to creeping expropriation and said that, they're like creeping expropriation, which process extends over time. They describe a creeping violation of the FET standard as a process also extending over time and comprising a succession or an accumulation of measures, which taken separately would not breach that standard, but when taken together do lead to such a result. And they found that the measures complained here, the contribution of the measures to the claimant's decision to sell its investment, and concluded by the cumulative effect amounted to a breach of the fair equitable treatment standard. I mean, my personal view, and this is not a view that is that I have any experience with, but just by reading on this case, I would be interested to see how it develops. But my personal view is that it appears to me that it may actually be more difficult to establish a creeping violation of the FPT standard. In some ways, creeping expropriation. I mean, I've always viewed expropriation as a bit of a more tangible form of a breach of a BIT, in the sense that, you know, it involves the taking of a property, you know, whether legally, whether subtly, but there's this notion of deprivation of the value. You can actually see it, you know. But, you know, where you're talking about a violation of the FPT standard, where it's a little bit theoretical, right? How do you even establish? I mean, yes, there are cases that establish what an FPT standard is and all that, but I think it then goes a little bit more into, you know, where most treaties have kept the definition of FPT quite broad. How do you use it? Would, I think, be more challenging to actually establish this creeping violation of the FPT standard. But yeah, that's just my 2 cents.
Okay, Gustavo, yeah, what
Yes.
are your views?
I'm more, frankly, I mean, from the moment I began practicing investment arbitration, I fairly quickly heard about the concept of creeping expropriation. I think anyone who practices will hear. Creeping FDI is somewhat bizarre to me. It's something that I haven't heard that often. And indeed, as you well point out, Vera, it was first raised in the case law in the El Paso versus Argentina case. And as a footnote, Argentina tried to have that award set aside on the basis that the concept of creeping FDI violation was a judicial invention. And therefore, the tribunal had exceeded its powers, but it was not sustained this basis for challenge, and the committee ruled that he had a basis in previous case law, and that in any event it could be considered an obiter. Now, I think the big difference between creeping expropriation and creeping FDI violation is that the reference notion is very different. When you talk about creeping expropriation, what you're referring to is the investment. So you're saying that the measures, little by little, diminish the value of that investment, right? So you focus always on the investment. Whereas the focus of this creeping FDI notion is not investment. You're not focusing on the investment. You're focusing on the promise or this notion of keeping the legal framework stable is right, which is at the heart of the FDI notion, or legitimate expectations. But just as a matter of common sense, I find it a little bit strange that you could say, well, you could breach a little bit the legitimate expectation. You didn't fully breach it, but you know, this kind of, or the same with discrimination. Could you argue then creeping discrimination? You discriminated a little bit, not too much, but a little bit. And then if you put all the acts together, well, that's a big discrimination. So there's a threshold notion. Now, I'm not saying that it's wrong. It sounds less intuitive, right? That you would need this notion to reach a finding of that there was an FDI breach or a discrimination breach. Because I mean, if you really can use the notion of creeping for FDI, then you know you could apply it for any of the other standards in a BIT. And I'm not entirely. I'm not saying this. You cannot have it. I'm not sure that you need the notion to be able to fully implement these protection standards.
Thank you so much. You actually said a very interesting point, and I will try to formulate my question. So you mentioned that you cannot be, you know, discriminated a little bit and then discriminated more and fully and entirely discriminated. I totally agree with you. But if you take different, you know, sub parts of what the tribunals consider as unfair and inequitable treatment, okay, we can put aside the sub notion of discrimination, correct? But if we focus on other sub parts, let's say the legitimate expectations, the expectation to have a stable and predictable legal framework, and wouldn't it make more sense? So you can indeed be a little bit unpredictable, change here and there the legislation, but it's still at certain points of the chain of events, it did not amount to a violation of the fair and equitable treatment standard. But by changing little by little the legislation at a certain point, can we say that you reach the threshold of the legislation becoming unstable and unpredictable? Can this be the case that certain parts of the FET are more prone, more susceptible to be considered under this angle of the creeping FET?
Yes, I mean, it's possible. I think it's a very much factual analysis, and it depends on whether the previous steps are independent or not. If they are not independent, I'm not sure you need the creeping notion. I mean, let's say that you say, like, you know, you promise me that, you know, this evening we'll meet at 7 p.m., right? And then, you know, you arrive at 7:05. You could say, well, you know, you didn't quite arrive on time, you know, it's a tiny bridge. And then, but then you say, well, actually not even 7:05, make it at 7:10. And then you keep pushing, and then at the end you say, well, I'll be there at 10 p.m. You know, at some point, obviously, it's too late. But the point is, you know, is it the gradual increment of these bridges independent, or is it just part of the same thing, and therefore it's just the crossing of the threshold that matters? Because if it's a crossing of the threshold that matters, I'm not sure you need necessarily to see it as a composite act of, you know, independent access in the notion of creeping expropriation. But I'm not sure I'm explaining myself clearly. So at this point, I'll let Alessa help me with this.
No, yeah, I completely agree with Gustavo, which is it is supposed. I mean, there are 2 points to it. Like what I said, I'm not sure how it would apply in the context of a breach of FET, and I think Gustavo has explained it even better than I have, which is to say that you may not even need it to prove a breach of FET by the very nature of what a breach of FET standard entails. You know, the fact that you could look at, you know, the way I suppose, because if you're looking, you know, at, for example, discrimination, you're looking at a stable legal regime, by the nature of trying to show that a legal regime has become more unstable for the investment or become more investor unfriendly, you would already be looking at possibly a series of acts, a series of legislation. And therefore there is a question of whether or not we even need to create this new notion of a creeping violation for creeping FET violation, as we have done so for creeping expropriation.
Yeah. Vera, if I can go back also to a scenario that I presented before with the 5 steps, and let's assume that each step diminishes the value of the investment by 20%. In the scenario of creeping expropriation, you need to see them as all together, because if you focus on one alone, then the diminution in value is 20%. So that would usually not get you to a finding of expropriation, right? Because you have the other 80% of the value of the investment left. So the only way you can really say, oh, this is, you know, substantial deprivation, if you take them all into account. Now, how would this play out in the context of FET? And that's why I was saying the point is, can you look at the acts independently or not? Because if the point is step 1, 2, 3, and 4, 5, and then it's only at 5 that, you know, you get to say there is a breach of FET, and you need step 1 to 4, then perhaps it makes sense. But if it's just a gradual increment, and before that increment you have no FET breach, and it's just that it's only at the point number 5 that you could really say there's an FET breach, then you can you need only to focus on step 5. You don't need step 1 to 4 as you need them in the notion of creeping expropriation. But again, it's probably easier to see it when, you know, you see a real factual matrix at play, and it may be easier to visualize. And I'm still open to being convinced that you need this notion of creeping FET violation.
Okay, thank you so much. I'm just thinking out loud. Indeed, in the context of expropriation, the notion of expropriation implies that at certain point the value will be destroyed. But as in the context of the FET, it's not necessarily the case. So the value may not be destroyed entirely. It may significantly go down, or even go down not that significantly, but let's say by half or not entirely.
No, I think it's irrelevant. In the context of FET, it has no relevance, because the focus is not the value of the investment, is the promise or the stability of the legal framework. And whether that causes you harm or not, well, it's a matter for quantum, but it's not part of the analysis.
Exactly, that's correct. I totally agree with you. I was just thinking, isn't this concept of the creeping FET, isn't this a significant extension of this notion? Because if we take, I think what the tribunal, when they use this notion, they try to look into separate acts, and they see that if we take all of them separately, number 1 to number 5, even the number 5, like none of them, these are just like normal regulatory changes. There was just change of legislation. Any state is perfectly entitled to do it, has sovereignty to do it. But then the tribunals saw the situation entirely in its context, and they see that this is unfair and inequitable only if you kind of look at all these steps separately and then entirely. So the sum is kind of bigger than the individual acts. And isn't this an extension? I think the tribunal, when they looked into separate acts, they didn't find any violation. And then they came up with this bigger concept that if you look into the bigger picture, all facts, then we see the violation. So my question is, isn't this an extension, a dangerous extension, or an extension at all?
Alessa, you want to go, or? I go? Okay.
Yeah.
No, I don't think it's an extension, Vera, because I think it's already, I mean, as Alessa was mentioning, you have the ILC articles on state responsibility, and you have reference there to composite acts. So this, let's say, power of tribunals to look at the totality of facts, acts, and omissions of the state is already provided for as a matter of customary international law. It is already an inherent power of the tribunal to look at the acts as a composite whole. And therefore, I guess the debate we had earlier was, do we need a different concept of creeping for this matrix? And I think that, still I'm not completely sure about what the answer is. And at this point, I'll give the floor back to Alessa.
No, I do agree. I would say instinctively, I would still come back to the view that I'm just not sure if there needs to be a creation of this new concept when, in effect, possibly tribunals may already have been applying this in determining whether there has been a breach of FET standard. And if it was the case that these individual acts may not have amounted to a breach of a FET standard, then there is a question of then maybe there wasn't a breach of FET standard. But I mean, but anyway, it comes back to the main point, which is that maybe we already have been doing this in practice in terms of dealing with FET standard. And I do think it just comes down to the difference in the nature of these breaches, because, expropriation tends to be associated with, one act, the taking of a property, the lowering of a value. But the problem is that the lowering of a value can take place not necessarily just by one act, it can take place gradually. And by that very nature, it would therefore mean that it could take place through a series of acts rather than through one act. And therefore the need to then, as a tribunal is called it, to deal with this gaping loophole in order to address such situations where a claimant says that his or her property has been expropriated.
Okay, so both of you agree that the notion of creeping expropriation is somewhat more logically justified than the notion of the creeping FET, which leads me probably to our final question today in the interest of time. How do you see the future of such claims of both, creeping expropriation and creeping FET? Because from my understanding, nowadays the tribunals often consider the breach of the FET first, because the threshold might be somewhat lower, and then they sometimes dispense with the question of expropriation altogether, saying that we found the breach of the FET, we will not delve into the expropriation at all. So what is your view, whether we will see more of such claims of both creeping expropriation and creeping FET, or is that something that is rather, marginal, and we should not over concentrate on these notions?
I think it would boil down, of course, ultimately how BITs develop. And I think one of the things that came to mind when I was considering this question was also that because of how broad, as you have pointed out, the first port of call for claimants tends to be FET, because it tends to be more broadly worded in a treaty. And then you can try to, one would think that, I would imagine most claimants would think, okay, let's try to fit this act into, let's say, there was a breach of FET. But I do think that there seems to be more and more BITs now, which have actually tried to confine or tried to define the FET standard with more granularity. And so saying that, because of this, they might, for example, say, there's certain acts, these specific acts constitute a breach of FET. And because of that, there may be, it may be then that, the trend may be that, for example, investors may want to then relook and see, maybe we might want to see, assuming that the BIT provides for protection against expropriation, they might want to try to fit in their claim within the context of indirect expropriation instead, because it becomes harder to fit that claim in within a more defined concept of FET. So that's my take on that.
Gustavo?
Thanks, Vera. I think, to the extent there is a future to investment arbitration, or as Toby Landa would say, to investor-state dispute settlement, I think there will be more creeping expropriation claims and more FET claims, creeping or not. And these are really the two main protection standards. So, use FET and expropriation. As you well know, Vera, indeed, FET tends to be a lower threshold, so it's easier for claimants to go for that one first. So the answer is yes, that there is a future for both. Now, also to the extent that we might start seeing more environmental claims and more environmental regulations, could also be an issue with that. And perhaps I guess what perhaps is a bit of an issue to me is when you apply the same notion of creeping to both FET and expropriation, it's then easy to fall into the trap of mixing up the two standards, and they are indeed very different standards. So that's something to keep in mind, that you could still look at facts as a composite act for the purposes of an FET claim without needing really the concept of creeping. And perhaps the only additional point in relation to the future of these kind of claims is that you also have some treaties, not that uncommon, where the only protection standard is expropriation. You don't have FET claims. So obviously for those kind of treaties, then it's all the more important to have expropriation claims and to allow or to potentially entertain creeping expropriation claims.
That's indeed correct, unless the most favored nation clause allows us to import other standards, as it sometimes happened or sometimes didn't. Thank you so much, both Alessa and Gustavo. It was a very interesting discussion. I really enjoyed it. We will see. We have some 4 minutes for questions from the audience. If someone wants to ask questions, you can either type them in the chat, or you can if you have this technical possibility, I'm not sure, but you can also ask them by video.
Yeah, welcome. Questions are more than welcome.
Yeah, I think you covered it so exhaustively, all of these sub-questions.
Let's explain everything.
No, Gustavo provided all the views. I think maybe all the questions that they have are related to the moot.
So yeah, as far as I can see, we do not have at this moment some additional questions. So I think at this there is
there is
some
one question.
Interesting. So I will read it. Just to clarify, does creeping expropriation requires expropriation to be proven at each step?
Well, can I go on this?
Yeah, sure, Gustavo.
It's a super interesting topic. It's a really good question because it's one point we didn't cover, which is that under the famous definition of Michael Risman, right, this colossus of U.S. scholarship, is considered one of the great international law and also investment scholars. When he defined creeping expropriation in a famous paper he wrote in 2004, he said that you have creeping expropriation when all of the series of acts in the change amount to creeping expropriation, but this is the crucial part, but no single act in itself amounts to expropriation. So in answer to the question, if you apply this definition of Risman, the answer is no. No single act can in itself be expropriation. So not only you don't need it, but you cannot have it, at least for the notion of creeping expropriation. And that was the definition that Professor James Crawford also used when he was advocating for creeping expropriation in Burlington. And but a few years later, there was this court, this judge in England, right? It's an English, high English court. It was the case of GPS versus Poland. And he was the first, to my knowledge, to criticize this definition of creeping expropriation. And essentially he said, well, you could have both. You could have a situation where you have in the same change creeping when you look at all the acts as a whole, but you could also have a specific act in that change that in itself is also, let's say, indirect expropriation, or at the end of the change, you could have direct expropriation. So in answer to that, it's a really good question. I think really the issue is very much still open. And it depends on what definition you go by. If you apply let's say, the Risman definition, then no act in the change can amount to expropriation in itself. If you apply the definition of the English High Court, then you could have a situation where you have both. You could have one act that is expropriation and then the whole change. So very good question.
Yeah, I think Gustavo covered very exhaustively. Alessa, would you like to add something?
No, I completely agree with that. I would have said that. I mean, if you go by the first definition, you wouldn't need to prove it at each step, and perhaps that is the fundamental conceptual reason why creeping expropriation had to be not created, but had to be defined in the first place. Because if you had to prove expropriation at each step, then by that logic, why would you even want to have to add an additional level of having to prove creeping expropriation?
Thank you so much. I see that we have received a couple of more questions. I don't know, Margarita, our moderator, can we use a couple of minutes, or we are already? I see that we are already. It's already 4 p.m.
As you wish. I can stay a bit longer. I mean, I don't know about Alessa. I think she wants to go out, but
it's quite late in Singapore, actually. I imagine. So I will start with the last question then, and then I will come back to the previous one. As a follow-up, how should we interpret Siemens versus Argentina, paragraph 236, which summarily states each step must have an adverse effect, but by itself may not be significant or considered an illegal act? How do we prove this adverse effect? Maybe Gustavo can start because he spoke about this example with 5 steps.
Yes, I think it adopts very much the definition of Risman, which is, I mean, for each step to be included in the change or in the set of events, it has to have some impact on the value of the investment. Otherwise, you would not even include this act in the analysis. And the way you include that act in the analysis is by showing that somehow it had a negative impact on the value of the investment. So that's something that you would have to prove in some fashion, quantum expert or some way. I mean, so yeah, to me, it's not like that paragraph from Siemens very much relies on the Riemann definition.
Okay, and then the final question was a theoretical one. What sources would you recommend to learn more about the date of valuation for creeping expropriations? That's basically a question, yeah. I think Gustavo already gave us quite a few of sources. Like
valuation, well, I mean, I think always the first one has got to be case law. I mean, if you're doing a moot court, your first line of argument has got to be precedents, because you want to see how tribunals apply this in practice, and then as a second step you can go to the literature and treaties and but the first one is always case law, because that's when you really see the issues being applied in practice, and you can then apply them to your own case.
Alessa, anything to add on the sources?
No, I completely agree. Case law would be the first port of call. And from the case law, you may find additional sources which the tribunals or the parties have cited. And of course, there will often be a lot of commentary out there, but I think the first port of call should always be to look at the decisions first, because commentaries will often sometimes express a certain view, but those may be useful as secondary literature.
Okay, if I may add, from my experience, I found fascinating the blog of Aswat Damodaran. It's the professor of economics in the New York University, and he has a very funny way of explaining all the difficult concepts. He's an economist, he's not a lawyer, but he treats all these issues of the fair market value or the date of valuation in his blog. So if anyone of our students who is present is interested in these issues, I think it's the way to go. Okay, thank you so much. I think these were all the questions we had. Thank you so much, Alessa and Gustavo. I think it was a great discussion. I really enjoyed it. I hope our audience as well. And thank you everyone who joined us today on this sunny or not that sunny day, depending on your occasion. Thank you so much, and hope to see all of you soon in person or virtually in other events. Thank you.
Thank you, Vera. Bye-bye.
Thank you, everyone.
Bye.